and you can hear it. So I don't know if you want to put it on something soft. There you go.
All right. You're recording, so have fun. You don't have to be silent yet. See if I can snag power down.
Do you need to make sure no one else walks in that door? Like an occupied sign or something?
Should.
Or do not disturb?
Have a key.
I have a key, but
Oh,
it's just
okay.
because I do training.
Yeah. And I put tape or paper over the.
Sounds good. Thanks, Byron. Ready when you are.
Welcome to Ethics for Social Workers, as interesting and entertaining as ethically allowed. We're going to cover 3 modules today. The first module will deal with confidentiality and privilege, TerraSoft, malpractice, informed consent, and documentation. The second module will deal with ethics in child, couples, and family counseling situations, ethics in group counseling, and ethics in the electronic age, which is becoming a bigger and bigger part of what we do as social workers. Module 3 is going to handle conflicts of interest, dual relationships, boundaries, transference and countertransference, and secondary trauma, which is a bigger part of what we deal with as social workers than people want to recognize. So I always cover that when I do an ethics training because I think it's an important thing to think about to take care of ourselves as we do our practice. Module 1 will start with confidentiality and privilege. We'll then cover TerraSoft. Most people know what they have to do in terms of TerraSoft duty to warn, but they don't actually know where it came from, so we'll be talking about that today. Malpractice and what to do if someone files a malpractice suit against you. Informed consent and documentation. Documentation is probably the most important protection that you have in cases of malpractice, so we'll cover that in pretty good detail today. Let's start with confidentiality. Most people kind of get the concept of what it is, but we'll go over that in depth. It requires a therapist to keep client information free from unauthorized disclosures. That means you can't reveal information that a client tells you without some sort of waiver or consent to do so. In the state of Ohio, we use consent forms or releases of information if a client approves for us to talk with someone else. Now, there are certain situations where you can release information even without a client's consent, and we will be covering those today as well. In Ohio, confidentiality violations are very, very serious matters, and they can trigger discipline such as loss of license to practice, malpractice suits, and now HIPAA penalties as of the last few years. So let's talk about a scenario. A social worker you work with takes a picture of her client and the client's new baby with her cell phone. What do you do? Think about it for a second. Now, this is not you, this is a social worker that you work with, but they've taken a picture of a client with their cell phone. Well, first of all, this could be a confidentiality violation because we don't know who's going to see that picture. Maybe the social worker's children look at that picture. Maybe they want to know who that is. Maybe someone will even recognize that person. So that is a confidentiality violation. Now, you as the social worker that have witnessed this need to mention to the social worker that this is not appropriate and that this could be a confidentiality violation. If the social worker persists in doing this, then we are mandated reporters to the board. You must let the board know that someone is breaching confidentiality on a regular basis and that your efforts to stop that practice have failed. Let's try another scenario. You're at the mall with a friend. One of your clients walks up to you and starts a conversation with you. What do you do? Now, I get asked this one a lot when I do workshops because it does happen, especially to social workers that tend to live in fairly small communities. One of the things that you can do is when you're first seeing a client and you're doing your informed consent, you can discuss with the client the need to have a process if they do run into you. And what I tell my clients is, if I run into you in a social situation, I will not acknowledge you to protect your confidentiality. However, if you talk to me, I will say hello and return your conversation briefly before moving on. I will not tell anyone who you are. Now, this means that if you're a social worker and you're with with a friend at the mall and someone walks up to you, after you're done talking to them, you can't leave with your friend, who then of course will say, "Who is that?" You can't say, "I can't tell you who that is." You're not allowed to do that as a social worker either, even though it seems like maybe that would be something that you're going to want to do. Your friend may recognize that if you can't say who it is that you just talked to, that's a client or maybe a client that you were just talking to, and that's why you can't say, but you cannot acknowledge that in any way. You need to protect your client's confidentiality. Again, this is a tricky situation because it does happen to us, but if you warn clients ahead of time that you're not being rude, you're simply making sure that their confidentiality isn't violated, clients tend to understand that and appreciate it. Now let's talk about HIPAA for a second. HIPAA is a federal law that actually protects client confidentiality. Now, there are civil penalties, as there always have been, if you violate a client's confidentiality. In fact, it can be $100 per violation up to a maximum of $25,000 a year for HIPAA violations. Now, I don't know about you, but I have not become fabulously wealthy as a social worker, so I don't want to pay $25,000 for violating clients' confidentiality. So again, I'm very, very careful. Even if a client's attorney calls me and says, "I'm the client's attorney, so you have the right to release information to me," I will say, "Not unless I know for a fact you're the client's attorney because the client has signed a release to talk to you." Other than that, I'm very, very careful with client information unless they've signed releases or there's another exception at play. Now, for the first time, HIPAA also made violations of confidentiality a criminal act. That had never happened before. But now you can not only get fines up to $50,000, but you could serve a year in prison for confidentiality violations. That's not something social workers ever had to deal with before. And I don't know about you, but I don't want to go to prison for violating someone's confidentiality. So again, I'm trying to be very, very careful about protecting client information. Now, what is the difference between confidentiality and something called privilege? Well, privilege is more of a legal term. Privilege allows the client to limit the admissibility of statements that they've communicated in confidence to a counselor. Typically, this is used in court proceedings, where a client retains privilege over their information. So if someone asks you, who owns privilege in this case, the answer is always going to be the client, or if you work in a medical setting, it would be the patient. They own privilege over their records. Now, there are exceptions. One exception would be if the client actually waives privilege by signing a release of information. Sometimes if I'm subpoenaed, I will take a release of information to court and have the client sign it if it's they that wants me to testify. That way I know that it's okay to testify on that date, and I'm very specific in the release of information. In cases of child or elder abuse, privilege is waived because you are a mandated reporter of any kind of abuse. Now, other crimes. Now, this is a little bit tricky because in the state of Ohio, we are required to report any felonies that we may witness. That's just a part of our code. But as social workers, we do have to protect client confidentiality unless we're mandated to report something. So it's a little bit of a trickier issue here. But the way that I protect myself in a case like that is whenever I see a client, I have them sign a release, the very first thing when I see them, that says if they reveal any crimes to me that they've committed that have never been reported anywhere before, or if they tell me they're going to run out and commit a crime, even though that's fairly rare, I do put that on a release of information and have them sign the release to the authorities and only to the authorities. So that way clients know right up front when they see me as a part of the informed consent process that I'm going to call in any crimes and report those if they report any crimes to me. If I'm ordered by a court to testify, I have to testify, and I do, and that waives privilege automatically. If a judge orders you to testify, you have to do that. I do let clients know that as a part of the informed consent process as well, so they know that if I'm ordered to testify, I would have to do that. Terrace off duty to warn situations. Those are other situations where you have to waive client privilege in order to reveal information to protect a third party, and we'll talk more about terrace off in a little bit. Civil suits and civil commitments are another exception to confidentiality law. If you're trying to commit somebody to an institution because they're a danger to themselves or others, you may need to reveal information that the client's in no position to release. Now, likewise, civil suits, if a client sues you, the expectation is that information is going to be revealed so that you have the ability to defend yourself. So it's understandable if you reveal information to your attorney. Now, this is not your relatives, your friends, your neighbors. This would be your attorney, and it's for purpose of protecting yourself in case you're sued by a client. If the client is a danger to themselves or others, you may need to reveal that information to the authorities or to a hospital for the client to be admitted. And then subpoenas. Now, subpoenas are a special case, and people tend to make mistakes with subpoenas all the time, so it's really important that we talk about this concept. First of all, with a subpoena, you have to respond. You can't pretend you didn't get it, even if you'd like to sometimes. I know I get subpoenaed on occasion because I work with a lot of court-ordered clients, and of course I would prefer not to have to go because I typically have to cancel appointments to do it, but you have to respond. You cannot ignore a subpoena. Now, here is the part that gets confusing for folks. You have to respond and appear with the subpoena. You do not have to testify unless the client has waived privilege. The client does still have client-counselor privilege. So unless they've waived that, you cannot testify unless you are ordered to do so. So typically when I go to court and I'm asked questions by attorneys after I'm sworn in, the very first thing I say is, I cannot testify here today unless I am court ordered to do so because the client retains privilege over their confidential information. Typically then, I sit back and wait for attorneys to argue and decide whether that privilege is going to be waived or not, and then the judge makes a final decision. That process can take a while. Sometimes I feel like I need popcorn to wait and decide and watch and figure out who's going to win that debate. Now, if you really feel it is not in your client's best interest to testify, you can attempt to do something called quashing the subpoena. I know it sounds more like a sporting event, but it's called quashing the subpoena. You need to call your attorney and do that, and in some cases that's the right thing to do. Several years ago, we were working with somebody who had victimization issues, and someone else wanted them to testify and wanted us to testify about their victimization issues. We moved to quash the subpoena because we didn't feel it was right to re-victimize that person by having them discuss their victimization issues on the stand, and we were successful in quashing that subpoena. It's expensive, it's time-consuming, but sometimes as social workers we have to do the right thing, and in this instance that was the right thing to do, so we quashed the subpoena. So always remember, when you go to testify, you need to say, since the client has not waived privilege, I need to be ordered to testify today, unless the client has waived privilege by signing a release of information. This is very important. Okay, trick question for you. Your client dies. Who can you release their records to? Now think about this one for a second. Who can you release their records to if the client or patient, if you're in a hospital setting, dies? Well, here's the answer. It's only the executor of the estate, and you must have proof that this person is the executor of the estate that you could put in the file. It's not any family member that calls you, it is not neighbors, it is not the news, it is not anyone else. It is the executor of the estate, and only with proof. Now, you may have noticed that counselors on occasion will go on radio or TV shows and talk about their clients. And I've been asked this question a lot. They seem to be violating this rule. How is that okay? Well, there are two things that may happen in this case. One is it's not okay, especially in the case of a client who's deceased who has inflammatory information that they would not have wanted others to know about. It's not okay for a counselor to go on a radio or a talk show or TV show and disclose that information. Think how you'd feel if you were revealing information about a family member to your counselor, assuming that information was going to be confidential, and then you later on die. Now, you may not be aware that that's been violated, but you wouldn't have wanted that, and you're not in any position obviously to come back and say, hey, I really don't appreciate that violation of my confidentiality. So counselors and social workers are bound to protect that information even if someone's deceased. I know if it happened to me, I would come back and haunt a counselor if they did that without my permission, because those things that I say I would want to remain private. Now, another situation might be a counselor goes on a radio or talk show and the client has signed a consent form. They do have the ability to do that and sign and waive that right to confidentiality, but in that case, hopefully, you've explained to the client everything that could happen as a result of that disclosure. Now, let's move on to Tarasoff duty to warn, which I'm sure most people have heard about, but most people may not know the situation that prompted Tarasoff duty to warn. Well, it was in 1969, and a gentleman named Potter told his therapist that he intended to kill Tatiana Tarasoff. Now, the University of California campus police detained him based on the counselor's report to them that he was dangerous and that he may hurt her, and so he was briefly hospitalized. He was then evaluated and released by a psychiatrist. In October of 1969, unfortunately, he did then kill Ms. Tarasoff. Now, Tatiana's parents filed suit then, alleging that Ms. Tarasoff should have been warned and Potter should have been detained. The finding in the case by the court was that therapists do have a duty to protect third parties from the actions of their clients. Now, this was the first time that anyone had ever held us accountable for reporting anything to third parties that had nothing to do with our therapeutic intervention. That had never happened before. Something I want to point out to you about this, though, is that for the time in 1969, remember, all we had back then was confidentiality law. So the counselor in that case actually did the right thing based on the laws and rules at the time. But hindsight is always 20/20. Because of what happened later, everyone was able to say, you should have warned Tatiana Tarasoff. Well, unfortunately, that can happen. I can tell you what all the right things to do are in ethical situations, but if something bad happens later on, hindsight is 20/20, and you may do everything right and still have it turn out that you're held responsible, even if it's not a rule or law at the time, and that's what happened in this case. So it's unfortunate. It's unfortunate that the rules at the time did not guide the counselor in the direction of notifying a third party, but now they do because of this case. So let's talk about what you would do if your client does express an intent to harm somebody. Well, you need to do what's called a Tarasoff assessment. Even if it's 4:59 on Friday afternoon, even if your session with your client is coming to an end and you're not going to be working with them after this and you have another client in the waiting room that's waiting to see you, you have to stop and do a Tarasoff assessment. You have no choice. It's the same thing with a suicidal client. You have to stop and do a lethality assessment. So, what do you do in a Tarasoff assessment? Well, you're going to examine the client's plan. How solid is it? How specific is it? What elements are present in the plan? Is it a clear threat or is it a vague threat? So there's a big difference between a client who comes into you and says, I'm so angry I could just kill someone. Well, that's not a very clear threat. They haven't even targeted anyone specifically. They're just basically blowing off steam and telling you they're upset. And that's understandable. I've probably said that before too, and I wouldn't necessarily want to be hospitalized in a Tarasoff situation. So everyone does that, but it's more of a concern if someone says to you, I have a gun that I bought this afternoon. I am going to ride my bike over to my ex-girlfriend's house because my car is broken down. I am going to shoot her this afternoon to teach her a lesson. Well, that's very clear. They're even telling you they have a means. They're actually telling you that even though their car is broken down, they're still going to find a way to go out and do this. So you very clearly have a duty to warn that person. It's a very, very difficult situation to deal with because we don't always know what clients are going to do, and that's the unfortunate part about what we do as social workers. People could change their minds. I've seen people become violent or suicidal over receiving bad news after they left the session. Did I know that was going to happen? No, and neither did they. But something changed between the time that I saw them and the time that they committed suicide or tried to commit suicide or attempted to harm someone else. We can't ever truly know what someone is going to do, but we have to do our best if someone is giving us this information to determine whether or not they really are going to carry through with that threat. Now, I'm going to throw a scenario at you and see how you handle this. Right after a serious shooting incident occurs at a school, your patient, who's had the same job for 15 years or more, tells you he wondered if he could do the same thing at work. He wondered if he could go into work and shoot everyone. He then tells you that he decided he could never do that. Do you have a duty to warn anyone? Well, that's a really good question. Most people, when I present that in workshops, they say you should warn just to cover your rear, honestly. But if you do that, he's going to lose his job. So, weigh this out very carefully. Did he tell you he was going to do it, or did he tell you he wasn't going to do it? In this instance, he said he thought about it, but then decided that he couldn't do it. Now, believe it or not, I had probation officers and a judge argue this with me, that I had a Tarasoff duty to warn. I did not think so, because I knew that he had not been clear about what he was going to do. He had said, in fact, he was not capable of doing something like this, and I notified the probation department, who then talked to the judge, which was the extent of my responsibility since this was a probation client. Had I notified the authorities in an attempt to cover myself, he would have lost that job, and that would have made him very unstable. So I did the right thing, but I have to tell you, that's a very, very tricky situation. Had he later changed his mind and gone out and followed through on what he had considered doing, people would have looked at me and said, you should have known, you should have done more. Well, hindsight is 20/20. I'm sure that would have been a very, very tricky situation, but I did what I thought was right at the time with the laws and rules that we had in place and the Tarasoff assessment that we currently have and are supposed to use. Now, could it have backfired? Absolutely. But again, I did the right thing. Now, luckily, there's at least some legal precedent for that. There was a ruling in Georgia in the year 2000 that came from the Psychiatric News, March 3rd of 2000. This is the Garner v. Stone ruling. And in the Garner case, a police officer had fantasies of shooting his boss, at least 8 other police and officials, and then himself. He tells his therapist that he's had these fantasies. He does not tell the therapist he's going to follow through. He simply mentions that he's had thoughts about doing this. No clear plan to actually do it. The therapist sits on that information for 2 weeks. I can't even imagine what that must have been like, to worry about having that information in your possession and not being sure what to do. But as it stands, the therapist waited 2 weeks to report that information, and then the therapist decided to tell the boss in the police department. The client was then demoted to dog pound duty, which is something they did with officers that they no longer wanted on the street, and then the officer was subsequently fired and sued the counselor. Now, the court in this case ruled that there was no imminent danger and therefore no duty to warn. Now, there were a couple reasons for this. One is the therapist waited 2 weeks with this information. It can't be imminent danger if you sit on that information for 2 full weeks before you report anything. But also, this person was saying, I've had these fantasies, but I'm not going to follow through on them. That's very different than someone who's telling you, I have this information and I'm going to do this and I have the means to commit this act. Now, it's a slightly different matter if someone says something to you like, I am going to go out in my car and drive as fast as I can and I don't care if I hurt someone. What would you do in that scenario? Well, that might be a scenario where you keep the client and try to calm the client, soothe the client, and give them other coping techniques. You may even then send them to a crisis center, but it's not necessarily a duty to warn situation. So let's throw another scenario at you. Your patient is suicidal. Do you have a duty to warn anyone? Well, let's think about this for a second. Your patient is suicidal. Do you have a duty to warn anyone? Well, a lot of people tend to say yes in this situation if the patient is suicidal. The interesting thing about duty to warn, though, is it covers third parties. So who would you warn if the patient is suicidal? You can't warn the patient that they're suicidal. Hey, you're suicidal, just wanted to warn you. That's not going to work. So you do have a duty to let someone know, but it's not specifically a Tarasoff duty to warn situation. You have to let the police or other authorities know, or your crisis center, so that hospitalization situation can be checked as an option. You also have to do a lethality assessment to determine how serious this client is about being suicidal. But it's not specifically a TerraSoft situation in and of itself. Let's talk about a really tough one. Your patient is HIV positive. Do you have a duty to warn their new partner? This is a tough one. Take a minute to think about this. Your patient is HIV positive. Do you have a duty to warn their partner? Well, here's what I would suggest, and I've gotten a couple of different answers from the Ohio Counselor, Social Worker, Marital Family Therapist Board. One answer is that since HIV is now such a widely known public health issue, you do not specifically have a duty to warn. But the other answer I've gotten is, we're not really sure. So probably what will have to happen is test cases to determine what should or should not have happened in a situation. The best guidance I can give you right now, and this is the policy that I follow, is if a client is HIV positive, I will try to talk with them about protection, care of their partner, and telling their partner, and I will work with them and support them in doing that. Now, this changes completely if your client says, I'm HIV positive and I intend to specifically infect my ex-girlfriend by having sex with her tomorrow because I'm angry with her, I think she's cheating on me, and that's why we're splitting up. Well, that's very different. In this instance, the client is telling you, I am specifically intending to infect, to harm this person because I'm angry with this person. They're giving you a specific plan. In my opinion, that is a TerraSoft type situation. They are telling you that they intend to harm someone. So you can warn in a situation like that, in my opinion. And I think that that would be seen as a reasonable act in court. But you never know. Hindsight, again, is always 20/20. One precedent that you have for this case, though, is that in the state of Ohio, it's a felony to deliberately infect someone with HIV. So one thing that I do know is that you would probably be protected by the law because it's a felony. And that felony has been tested before. I know of at least one case where somebody was sentenced to prison for attempts to infect someone that they did not reveal their HIV status to. But that's a tough one. That's a very, very tough question and a tough situation. What that highlights is the fact that as social workers, we're going to run into very, very, very tough situations. I work with court-ordered clients, so I tend to feel like I've seen a lot of very tough situations, but you never know what will come your way as a social worker. You never know what you'll have to deal with that's a tough situation. So let's talk about what happens when things go wrong. Let's talk about malpractice for a little bit. Well, what is malpractice really? Malpractice is a civil suit to recover damages resulting from unprofessional actions of a social worker or counselor. It's brought by clients against clinicians where the clinician did not meet some standard of care. Now, what this can mean is you either did something you weren't supposed to do to the client, or you didn't do something that you should have done. You were negligent in some way with the client's care. So it can be either one of those things. It literally means bad practice. It's a failure to exercise the degree of skill that's expected of other professionals in your same position or in a similar situation. If you're acting inconsistently in a manner with what typically would be done as a standard of care, maybe trying interventions that don't have any basis, in fact, for being effective, abandoning your client, not reporting if they're suicidal, breaching their confidentiality, all of those could be examples of malpractice. Now, here's the thing about malpractice suits. The burden of proof that harm took place is the client's. Now, keep in mind, though, that harm in this case is usually mental. So who is the best person to report on whether the client was actually harmed? It's the client. And that's difficult because there's no standard to measure that by. And the client is the one who stands to benefit if they're successful in suing you. So this is a really tricky issue for social workers. If you were a doctor and you failed to set someone's broken leg properly, there would be x-ray evidence that you failed to do your job properly. There would be specific, measurable outcomes that you could look at objectively and say the doctor did not do what they were supposed to do. But again, since we're relying on what the client is saying and the fact that they are reporting that they were harmed by your intervention or your lack of intervention, then unfortunately we have to take their word even though they benefit from the suit. So it puts us in a difficult position. Now, they do have to prove that they were harmed in some way and that the actual injuries were sustained. So they can't just say, I was depressed because of what my counselor said. There does have to be some standard to show that, yes, they do appear to have suffered from depression. But again, that's difficult to prove. What's even tougher to prove in court, though, is whether a social worker's actions actually caused that impact. So that is one thing to consider, is that as social workers, the client would have to prove that we actually caused that harm. Now, the fact that our premiums for social work malpractice insurance are still fairly low suggests that successful malpractice suits against social workers are still fairly rare, which is a good thing, but the numbers are increasing. I know a couple years back I called my provider of insurance and I said, I'll bet with the economy being in the position that it's in right now, you're seeing an increase in malpractice claims. And the insurance adjuster said, you wouldn't believe the increase we're seeing in insurance claims. I was just curious, so I had called to ask the question, but I was not surprised by the answer that I got. Now, from 2005 to 2008, according to Dolgoff, Harrington, and Lowenberg, the most common complaints and lawsuits filed against social workers insured by NASW Trust were incorrect treatment, sexual misconduct, suicide of the client, state board complaints, failing to report abuse, and dual relationships with clients. So those are things to be very, very aware of as you're practicing. Now, the biggest area that we've already talked about is failure to obtain appropriate informed consent. That is one area where you can make a big impact on your ability to be successfully sued. Make sure you're educating clients. I spend most of my first session with them educating them on the process, what they're going to go through, what the services look like, and we'll talk a little bit more about informed consent in a little bit and what should be in your informed consent practice. But the point is, it's very, very crucial to go over informed consent policies with your clients so they know what to expect with your interventions. Saves a lot of trouble with malpractice suits. Client abandonment, let's talk about that because most social workers don't think of that as an issue, but it's one of the most successfully sued issues in our business. And it's called client abandonment because you're basically terminating client treatment even though there were no results, or even though the client still wishes to stay in treatment, or for some reason that's not healthy for the client. It could be failing to respond to requests for emergency treatment. It can be failing to provide services when you're on vacation. Believe it or not, that can be considered abandonment. If you tell a client that you need to end after 8 sessions, as some managed care companies want you to do, but the client is still clearly in distress and crisis and you do nothing to try to increase the number of sessions, that can also be considered client abandonment. And if you transfer a client simply because you're having countertransference issues with that client or some sort of reaction to what they're saying, that also could be considered abandonment. Most therapists will tell me that if they have difficulties in working with a certain client, they immediately try to transfer. Because of abandonment, you need to examine your own process first and see if there's anything that you can do before you transfer. Now, I will tell you that I think where malpractice is concerned, the best defense is a good offense. So, I always try to treat people with respect. That means that when I come out to the waiting room and get my client, I shake their hand. I say, thanks for coming in today. Nice to meet you if it's the first time I've met them. I introduce myself. I'm gentle and respectful. You would be amazed the number of agencies that I go into where a clinician comes out, they bark a name, they turn around and head back to their office, and the client is just expected to follow behind them. That's not how I would want to be treated if I was in a doctor's office or a counseling center. We need to be mindful of how we treat clients, and we need to be respectful of clients. So I try the first time I meet them to shake their hand, introduce myself, and say thanks for coming. And I work with court-ordered clients, people who have at times hurt other people. I think it's good to model respect for them, but I think it's also just really important for me to treat everyone with respect. People that I work with have often been judged, and it's important to let them know I'm not going to judge them. I do judge behaviors as inappropriate, but I don't judge people. I think this helps a lot in creating a good therapeutic rapport that can affect your relationship with them down the road and prevent malpractice as well. I empower people by explaining what's happening, their options, and outcomes. One thing that we make a big mistake with as social workers is we assume that clients know what our intervention is going to look like because we know what it looks like. I work with the courts a lot. I know what the court process looks like, but that doesn't mean my clients do. I work with a lot of adolescents, and they and their parents come in, and I'm doing a court evaluation on them, and they have no idea what's going to happen to them. And they're scared. They're concerned. So oftentimes, I'm the first one that sits down and explains to them what's going to happen next in the court process and what's going to happen next during my evaluation. And they're grateful for that information. I can't tell you how many times they thank me for that information. But the reason I remember to do that is because I know that they don't understand what's going to happen next, even though I've seen it a million times. And I think as social workers, we fall into the bind of thinking that people know what's going to happen because we do. Put yourself in the client's position as much as possible and educate them about what's happening to them, what's going to happen next, and what their options are. And again, this is where informed consent comes in, because when you first see a client and you go over those things, you're giving them the information that allows them to consent to whether or not they want treatment from you and they want to continue with the process. Be gentle, be clear, calm, and concise with clients and their families. If you have to confront about a behavior, try to confront gently if at all possible. People respond better to kindness than they do when you're not kind with them, even if you're feeling like you're getting frustrated by their behavior. That's not going to help the situation, and it's not going to help build that rapport. So try to remain calm. Listen to clients. Listen to what they're telling you. You know, I give the example in workshops that I do where I've said, from now on, I've talked to all of your employers, you're going to be paid in Snickers bars, because I love Snickers bars. So everyone is going to be paid in Snickers bars instead of paychecks from now on. How does everybody like that idea? And usually everyone in the audience will tell me they don't like that idea very much. Well, why is that? Because they need money to pay rents, mortgages, bills, and so forth. Snickers bars aren't going to cut it. But if I'm saying, well, I like Snickers bars, so I ought to be able to get paid in Snickers bars, and I think that would be good for you too, I'm not really listening. I'm not really listening to what the clients need or what the people in my audience need. They don't need Snickers bars. They need money to pay rent, mortgages, and so forth. So it's very important that we listen to clients, because what we think they need and what they think they need are often two very different things. And the client has to live their life, right? So we want to make sure that we're hearing them. And again, I think that ends up being very, very good defense against malpractice suits. We need to remember that patients and clients are vital to their own care, and we need to give them the ability to consent to that care and build a partnership with them as long as they know what's happening to them. It's very important. The Code of Ethics literally spells that out in Standard 1.03. Social workers should provide services to clients only in the context of the professional relationship, based when appropriate on valid informed consent. We need to be clear and concise. It needs to be an understandable language so that a client has the right information to consent. Okay, what is informed consent really? I've mentioned it several times. Your agency, if you work in an agency, probably has forms. If you work in private practice, you need to have your own forms where you're literally having clients sign a permission slip giving permission to work with you. Mine's 2 pages long, and the reason is because I need to explain all options to the client. I need to explain the services. I need to explain the frequency of services so that they can make an informed decision about what they want to do. Now, frequently, clients don't even realize they have these rights. I'm always stunned at the number of clients that come in my office and don't even look at my credentials. They just assume because I sit behind a desk that I know what I'm talking about. But I could be the cleaning person who just sat down for a minute. They don't know. So we need to educate clients as to the fact that they have rights to figure out whether they want to be involved in this therapeutic relationship or not. And it's important that we give them that, because we at all times are trying to empower clients. We need not to overwhelm clients with too much information, but to be very clear with them about what their options are. Okay, let's talk about how that looks in practice. And as I said, my form is 2 pages long. It has that much detail to it. It covers things like the type of services that we have, the purpose of the services, and alternative treatments and other options that are available to them. I explain the risks and benefits related to the services for them. I do have to let them know that counseling is not always going to tickle. There are going to be times where it can cause anxiety. It can cause some disruptiveness in their life when maybe things come to the surface that they've never dealt with before. I let them know that we've had positive outcomes with the type of treatment they use. What would it be like if you went to your doctor for pneumonia and they gave you an antibiotic and they said, you know, I don't know how long it's going to take to use this antibiotic, so just keep using it forever. I don't even know if it's going to work. Well, we don't like that. We like to know that the service is going to be limited and it's going to work. And we have a right as social workers to give them that information, and they have the right to receive that information. We need to let them know how much the service is going to cost, how long it's going to last, the importance of preparing clients for termination, and the fact that someday this will terminate, this relationship. It will not last forever. If it's a managed care relationship, I need to let them know how long the service is going to go. Because managed care companies often tell you, you have 8 sessions, so you need to pass that information on to the client. If there are going to be interruptions in service, such as your vacation, how are clients going to be handled? Now, I always tell my clients, I'm going to be gone this week, you're going to have a sub as your therapist. I tell them who that is and give them that person's experience level. Also, on my voicemail, I always say, if this is a crisis, hang up and dial the local emergency services network, and they can help. So all of my clients know that number, they have that number. I've covered that in case there's a crisis. You must give them that information. You need to let clients know they have access to their files. Under HIPAA, clients have a legal right to inspect and obtain copies of their records. I can't tell you how many times I'll go try to get a release of information for a client and the agency won't release records to me, and I'll tell the client, well, you need to go and get your records because you have a right to them, and they come back and tell me the agency wouldn't give them their records. Now, that's not legal. You have to give clients their records unless you can prove that it's harmful to them in some way for them to have their records, but you have to prove that. Now, you can ask for that in writing, that they request their records in writing, and there can be a charge for giving them those records, but the point is you have to give them their records. You are not allowed to not give them their records. Now, let's talk about what happens if a suit is filed. What do we do if somebody files a suit against you? Well, first of all, get a lawyer. It is very important that even if your agency has a lawyer, you get your own. Gather your documentation, prepare a response. You cannot change your documentation at that time. Once you've signed off on your documentation, it's a legal document. You cannot change it. Do not communicate any further with the client. You don't want to compromise your own defense. Carry liability insurance and use your liability insurance in a case like this. Your own, not the agency's policy. This is a big mistake social workers make. They'll say, my agency has a policy, so I don't need a policy. And you know what? That's not going to cover you. That's going to protect the agency first and foremost. So check that you have your own coverage and then use your own coverage. And when you retire, just as an aside, or if you leave the field for a few years, get what's called a tail so that you're still covered in case something happens well after you've left the agency. Because sometimes clients sue after you've already retired. Well, you still need coverage. You need what's called a tail. One of the best protections, and we just talked about it, is documentation. Make sure you have your proper documentation. Your documentation should always be clear and concise, provide relevant information, use primarily facts and clinical observations, differentiate between fact and professional opinion, and I use client quotes whenever possible because I like to make sure that people know that the client did in fact say this, and I can't tell you how many times that's mattered in a legal setting when a client has said, I never told her that, or I told her that and she was fine with it, and I've been able to say, ask client, client told me no, they never do this, and that's been very, very helpful. Never alter your notes later. Make sure that you get them into the record as soon as possible because you never know what could happen. I was put in a situation a few years ago where I had to reevaluate a bunch of clients who had just been assessed at another agency. Unfortunately, that clinician passed away suddenly and unexpectedly. Those clients all had to be evaluated by me because they hadn't done their paperwork. And that's stress that clients shouldn't have to go through. Try to keep up on your paperwork. I know it's hard. I know we're busy, but try to keep up on that paperwork. If you did not document it, it did not happen. And remember, in Ohio, you have to keep that documentation for 7 years. Now, assume that your client is going to be reviewing their information, so make sure you don't write things that could be harmful to the client or judgments. Make sure you keep it to facts and professional opinions. And assume that anything you write can go to court. My stuff does quite frequently, but you never know what piece of paper, what document you write may go to court. So just make sure that you document clearly, concisely, and it's objective as possible in case your documentation goes to court. So I'm going to talk with you now about some examples of reports that were done poorly. These were insurance claims that were based on automobile accidents. But it's amazing in some cases just how much a comma in the wrong place makes a huge difference. One person wrote, coming home, I drove into the wrong house and collided with a tree I don't have. Another person wrote, I thought my window was down, but I found it was up when I put my head through it. Another person wrote, I had been driving for 40 years when I fell asleep at the wheel and had an accident. Obviously, that person was extremely tired. My car was legally parked as it backed into another vehicle. Another person put, the pedestrian had no idea which direction to run, so I ran him over. That's kind of really tragic, I guess, if you're trying to eliminate pedestrians that way because they don't know which way to run. I told the police I was not injured, but on removing my hat I found I had a fractured skull. Another person wrote, the accident was caused by me waving to the man I hit last week. Poor guy. And last but not least, I pulled away from the side of the road, glanced at my mother-in-law, and headed over the embankment. Okay, now that's a family counseling issue, it sounds like. But the point is, sometimes when we write things, we don't realize how it sounds. So make sure you proofread all the documentation that you write. Make sure that you use collateral information if possible. I was told recently that we're one of the few domestic violence providers in town that actually asks for previous legal history of domestic violence and other crimes. Why wouldn't you want to know that if you're doing a report? To me, there's a big difference between someone that's done something once and someone that's done something 7 times. Or someone that has previously had a history of assaulting therapists. I would certainly want to know that. Also, never write things in absolutes if you can help it. Never write something like someone could not or would never reoffend or relapse, etc., etc. Never write things like there is no risk. Believe it or not, people do things like that. And you're staking your reputation on an absolute. Be very, very careful about doing that. Progress notes in particular, it's important to keep current on those. I know we're all busy, I know it's hard to keep paperwork up, but it's really important to keep progress notes current. Make sure they have things like the date, length of session, whether it's individual, family, or group, the content, quotes, signature, brief mental status. I always do a mental status when I see clients. You'd be surprised how they can look like they're fine, but really be deeply suicidal. What are the reasons that we do things like progress notes and documentation? Well, it describes the client's situation and helps with continuity of care. We can tell what's going on with the client even if we're not the therapist client or the therapist that's working with the client. Let's say that therapist is on vacation and we have to pinch hit. We'll know exactly what's going on. We'll know all the relevant details. And it is some protection against negligence claims. Now I'm going to give you, in closing, an example of the very best report that I think I've ever heard written. This has been on the internet for quite a long time now, and I use this whenever I'm doing a workshop, and I like to close with it when we talk about documentation because it's a great example of clear, concise documentation. This is actually done for an insurance company. Dear Sir, Madam, I am writing in response to your request for additional information. In block number 3 of the accident report form, I put trying to do the job alone as the cause of my accident. You said in your letter I should explain more fully, and I trust the following details will be sufficient. I am a bricklayer by trade. On the date of the accident, I was working alone on the roof of a new 6-story building. When I completed my work, I discovered I had about 500 pounds of brick left over. Rather than carry the bricks down by hand, I decided to lower them in a barrel by using a pulley which fortunately was attached to the side of the building at the 6th floor. Securing the rope at ground level, I went up to the roof, swung the barrel out, and loaded the brick into it. I then went back to the ground and untied the rope, holding it tightly to ensure a slow descent of the 500 pounds of brick. You will note in block number 11 of the accident report, I weigh 135 pounds. Due to my surprise at being jerked off the ground so suddenly, I lost my presence of mind and forgot to let go of the rope. Needless to say, I proceeded at a rather rapid rate up the side of the building. In the vicinity of the 3rd floor, I met the barrel coming down. This explains the fractured skull and broken collarbone. Slowed only slightly, I continued my rapid ascent, not stopping until the fingers of my right hand were 2 knuckles deep into the pulley. Fortunately, by this time, I had regained my presence of mind and was able to hold tightly to the rope in spite of my pain. At approximately the same time, however, the barrel of bricks hit the ground and the bottom fell out of the barrel. Devoid of the weight of the bricks, the barrel now weighed approximately 50 pounds. As you might imagine, I began a rapid descent down the side of the building. In the vicinity of the 3rd floor, I met the barrel coming up. This accounts for the 2 fractured ankles and the lacerations of my legs and lower body. The encounter with the barrel slowed me enough to lessen my injuries when I fell onto the pile of bricks, and fortunately only 3 vertebrae were cracked. I'm sorry to report, however, that as I lay there on the bricks, in pain, unable to stand, and watching the empty barrel 6 stories above me, I again lost my presence of mind and I let go of the rope. The empty barrel weighed more than the rope as it came back down on me and broke both my legs. I hope I furnished the information you require as to how the accident occurred. Okay, I love that story, but part of what I love so much about it is it's very clear. It's concise. You can visualize exactly what happened. It's factual. This person has a lot of emotion, I'm sure, about what happened to them, but you don't see the emotion, you just see the factual account of what happened. That's what we want to do as social workers and clinicians when we write our reports, and that's the best insurance against malpractice that we have. Okay. All right.
A great story.
Isn't that a great